Well, good afternoon, everybody, or good morning to you, depending on where you are. And welcome to our McGuireWoods webinar, DEI Programming and Peril, How to Weigh and Hopefully Reduce Relative Risk. My name is Brian Barger, and I'm a labor employment partner here in our Charlotte office. And joining me here today is Sarah Wake, my friend and fellow partner up in Chicago. Want to say hi, Sarah?
Hi, everyone. Nice to be with you, and thanks, Brian.
Well, we're glad you're able to join us today, but before we dive in, let me just go over a couple of housekeeping items, and then we'll get to the meat of our programming. So on your screen, among other things, you should see a couple of different icons. In particular, there's a resources icon towards the bottom, which should include a copy of the presentation, but if you want to, you can either print that now for taking notes today, or if you don't have time to do that now, certainly afterwards, just know that you'll get a copy of the presentation itself via email in a PDF form. So you can do it either way. Likewise, you should see a Q&A feature also towards the bottom. You can use that feature to ask questions throughout the webinar. We're going to hold questions to the end, and we're hoping to get to them. But if for some reason we don't get to your particular question or we simply run out of time, feel free to email Sarah and me directly or anyone else within your McGuireWoods contact list. We're all just happy to help you. Speaking of McGuireWoods contacts, just know that this is not legal advice. This is a general interest webinar, and so this is our disclaimer about that. I know for many of you, we are your counsel, but this is technically not legal advice in that capacity. We're glad to help you. Likewise, if we're not your counsel, boy, we'd like to be. So just ask Sarah and me anytime, and we're glad to lend a hand. So with that, that's it for logistics. We'll go ahead and start off with just a word to the wise about sort of this area. I know, frankly, it's hard to believe. You think back to the beginning of January, January 21st, when the first executive order dropped in this space about anti-DE&I initiatives. It's hard to believe it's been a month. And in that month, boy, there's been a lot of information. I know that we've done a lot of different webinars and different communications about that. I've read a lot of articles. Sarah has as well. Some of them are great. Some of them are not. I'll be honest, there's a lot of confusion. And it causes, just a lot of anxiety. But, it's sort of funny, though, that we get a lot of different questions, really, that go, in many ways, to the heart of what does DEI really mean and do. I'll give you one question I had. This is true. I'm not making it up. I won't name names. One person actually, in a conversation, said to me, I just cannot believe that they're cutting all this federal DE&I activity across the programming spectrum in the federal government. It's just awful. Don't you think that's going to have a massive increase in drunk driving across the nation? Like, well, maybe if that's what DEI meant, right? Now, that's not the case, right? And so I think when you think about this for yourselves, just understand that DEI comes in all sorts of flavors, right? What it means to one person is not what it means to somebody else. And that's because how you describe it, how you design it within your organization really sort of runs the spectrum many times. And likewise, when you're looking at cases on this, legal alerts, guidance from the government or otherwise, you've got to really think very fact specifically about what that means for you and how that compares to your particular circumstance. So we're going to try and give you some general guardrails. But just know that I think when you're doing your own assessment, you really got to sort of dig in into the particular facts, because here, unfortunately, the facts really matter. And so we're going to give you a short update on sort of what's been going on with respect to agency enforcement focus, if you haven't heard. I'm sure you have, but we'll give you a short reminder. We're going to talk also a little bit about what the common legal attacks are, where the firepower in this area is. And then we'll get into different components. When you look at DEI programming itself, again, they come in all sorts of shapes and sizes, but some shapes, frankly, are riskier than others. And we'll talk about how to attest to and sort of go through that list. And then we'll end with some practical tips, things that Sarah and I have been talking to people about throughout the country. So again, just as a starting point, just to get our mindset sort of in the right frame, I would just say this at the outset. There is absolutely no doubt, I think in most people's minds, frankly, but certainly not mine and Sarah's, that diversity and all the good work that people on this webinar do day in, day out to advance equal employment opportunity and to make sure that people are welcome and included and active and thriving in your organization, that is super important work. And, and I don't think anybody really disputes that. I think where the dispute is comes from two directions. Number one, sometimes, people do things in the name of good activities that can cross legal lines. And the same thing goes in the area of diversity. You saw this in some of the Students for Fair Admissions case action coming out of the Supreme Court the other year, but you see this in other areas too. And I think it's just important to understand that when it comes to DE&I activities, things that you engage in, the particular tactics for how you achieve an equal opportunity sort of diverse workforce, the tactics matter. And some of those tactics run against rules on Title VII. And for example, Title VII law since the 60s has been that it's unlawful to take into account as a positive factor or a negative factor race, sex, gender, national origin, et cetera, with respect to things like hiring, promotion, et cetera. Even if it's in the name of advancing really important diversity sort of goals and outcomes. At the end of the day, you're not allowed to do that. And so that's sort of one limit. There are limits. Just because a program sort of has a diversity tie to it, is engaging in positive things, doesn't mean that it can't be sort of restricted in some way. And there are all sorts of legal restrictions. And we've done some other webinars earlier in this series about that. We're not going to spend a lot of time talking about that here today, but if you want to go back to some of our earlier webinars, they're all online, and you can certainly pull those down. I think the other thing to remember, and I think this is the harder thing, at least for me, and my goodness, Sarah and I, we've been doing this work for a long time. I know a lot of you have as well. And when you do that for a long time, it's really easy to get sort of a little siloed. And what I mean by that is, since this is what we live and breathe every day, it's important to recall, I think, when you're looking at your own programs, that different people have different perspectives about whether they're a good thing or bad thing. And I think in general, what we've seen over the last 10 years, and I think it's only going to pick up speed, is there are a lot of people who are not just looking at the law in this area, but thinking long, deep thoughts about whether from a political standpoint or even a philosophical standpoint, certain DE&I activities are beneficial or not. And so I would just say, when we talk about this, things that we're going to get into in a second, they're a challenge, right? Definitely. But it's also an opportunity. It's an opportunity here at this juncture to pull back and ask yourself, why exactly are we doing certain things? And is this within the lines? And not just is it within the lines, but is it effective? Is it doing what we think it needs to do? Is it achieving what we hope it's achieving? Or is it in fact having consequences that we really didn't think about? I think those are big macro kind of business questions that are way beyond law that are good things to ask in this space. So we're going to talk about the law here for a second, and then we'll get into the individual programming. So I'll turn it over to Sarah to chat a little bit about where we are in the landscape.
Thank you so much. We're going to start, as Brian said, by just giving you a little bit of an overview about where we are. We're not going to spend too much time on this because I'm sure that most of you are familiar with the executive orders and the framework that's set forth in those orders, but we wanted to do a little bit of calibrating. And we'll start with this executive order entitled Ending Illegal Discrimination and Restoring Merit-Based Opportunity. This is a bit of an aside, but the titles of the executive orders remind me a little bit of Hallmark or Lifetime movies, like the Christmas I Fell in Love with the Baker from My Hometown. And it's like pretty obvious from these titles what they're going to contain, but nonetheless, really important to read them with detail and to figure out which parts of these orders may apply to you and what's said in the orders. And so this first one that came out, on January 21st, Brian took great care to include some resources for you here. There's a link to the actual executive order in the slide materials, the fact sheet, and then an article that our firm wrote about the executive order that we hope you'll find helpful. But in a nutshell, executive order, well, we'll call it 14173 is its number, did a few notable things. The first one is that it revoked Executive Order 11246, which a lot of people think of as the affirmative action executive order. So 11246, among other things, required federal contractors to take affirmative action in employment with regard to women and minorities if those groups were underrepresented in job groups. So I always think it's important. I think many people, not working in your space, but many people in general think that affirmative action and Executive Order 11246 required people to make hiring decisions based on race, and that was something that historically was happening. That's actually not the case. 11246 required you to look at your workforce, look at job groups, compare them to market availability, figure out where you're underutilized, and then enhance efforts to broaden the pool essentially of people who might apply to those positions. 11246 never stood for the idea that you could hire somebody on the basis of a protected class, because of course that is prohibited by Title VII and by other laws. So 11246 is no more. You no longer have to take affirmative action in employment related to women and minorities if those groups are underrepresented in your workforce. A lot of confusion I see with my clients is this notion that, okay, we don't have any more affirmative action obligations. That's not quite right. You still do have affirmative action obligations for now related to protected veterans and individuals with disabilities. Those are statutory requirements that are not touched by this executive order. So tying it back to our theme of programming, if you're thinking about your programming related to diversity, equity, and inclusion, if you're a federal contractor, you do still need to take affirmative action related to your protected veterans and individuals with disabilities. You cannot, should not, now or ever, make hiring decisions on the basis of those protected classes, but those affirmative action obligations are still in place for protected veterans and individuals with disabilities. You also can still gather data related to how your workforce looks and the composition of your workforce. You can still look at your job groups. You don't have affirmative obligations to do that anymore. But if you want to look at and rely upon those data to think about how might we broaden a job pool, you still certainly could do that. There's just not the OFCCP who will be coming to visit you if you do not do that. But certainly, I do have some clients who are still interested in how their workforce looks and how that factors into the way they're thinking about places where they go for recruiting fairs or where they post jobs. And I think that speaks to a broader issue that Brian touched on earlier, which is I don't think the right answer is to completely do away with all your DEI programs for the reason that Brian touched on initially, which is that, of course, diversity has tangible benefits in the workplace. And if you're like me and a little Pollyanna about things, it's also the right thing to do from the moral or human perspective. And it certainly, to me, could come across to people like the messaging is you need to get rid of all these programs. But I think the messaging, at least from me and from Brian too, I think is you need to just really think carefully about those programs and how you're talking about them and implementing them and what they are actually doing. Off my soapbox and back to the executive order. The executive order also required 2 certifications in every grant or contract agreement. The first one was the recipient of the grant or contract had to agree that you don't operate programs promoting DEI that violate, the word violate is in there, any applicable federal anti-discrimination laws. And then you also have to agree that your compliance with those laws is a material term to receiving money from the federal government as a result of your contract or grant. As many of you know, and Brian and several others here wrote a really great update on this. I think it was published yesterday, Brian, or maybe the day before, that gave a great summary of the injunction. So the parts of the executive order are currently enjoined. Specifically, an agency can't require you to make those 2 certifications that we just talked about, and they cannot terminate any equity-related grants or contracts, which was another part of that executive order. The Attorney General can still investigate DEI programs, but as of now, they can't bring any False Claims Act enforcement actions related to that certification provision, which that was one of the notable features of the executive order. Is there is much more of a presence of the False Claims Act related to those certifications, meaning if you certify that you're complying with the anti-discrimination laws, but you are in fact not, that is a material misrepresentation such that you could be subject to a False Claims Act claim. Something that I think is, I am in the labor and employment group with Brian. Thankfully, it's a wonderful group and glad to be a part of it. I'm also the co-lead of our higher education team. And I wanted to point out, because I know many of the folks who signed up for this webinar are institutions of learning, either K through 12 schools or of higher education. It's really important for educational institutions to know you were already certifying that you comply with the anti-discrimination laws in the context of your program participation agreements to receive federal financial student aid. So a lot of times the PPAs, the program participation agreement, it will go through your financial aid office. And oftentimes I've experienced that the legal offices at colleges and universities haven't reviewed them or didn't know that there is that clause in the program participation agreement. You've been certifying for years that you don't discriminate in violation of Title VI. So I think it's possible. I'm not trying to be a fearmonger in any way, but I do think it is possible for colleges and universities that sign program participation agreements. The temporary relief that is given in terms of the injunction, where there cannot be any certification requirements and there can't be any False Claims Act enforcement actions based on the certification requirements in the executive order. I think that someone could easily argue that for institutions of higher education who receive federal funds, that they were attesting to this long before the executive order and separate from the executive order. And so that's just something for those of you who are colleges and universities to be aware of. I would be looking at your program participation agreement and talking to your financial aid folks about that, just so they understand, what's in that agreement, and that given the climate that we're in, it probably is good for the legal office to look at those things. That's kind of the obligations in 14173 related to federal contractors and subcontractors, but it also creates, the executive order also creates obligations for all companies. Number one, it creates new federal enforcement priorities focused on DEI initiatives in the private sector and higher education. I think you all probably are aware, if you're in either of those sectors, that it's quite possible that you could end up on a list of people who the government is taking particular interest in. That still could certainly be the case. And the second thing is the executive order directs, as a part of the enforcement regime, that each federal agency has to identify certain targets over the next 120 days. And in the space I live in, I do know this is a significant concern for some of my higher education clients about what does it mean if you're on that list, and what steps should you be taking to mitigate the likelihood that you might be. So what are the most common legal attacks on DEI? I want to give Brian and our colleagues another plug, which is this webinar that we're doing today was actually part of a 4-webinar series. I believe it was 4, that did a general overview of the executive order, litigation trends related to DEI, a hot topics in higher education webinar related to DEI issues in higher education. And then this is the 4th installment. Those webinars are all available on our website. We can also, probably send them to you, a link to that landing page when we send you information about this webinar. But certainly, if you haven't, the litigation trends webinar I thought was particularly interesting, even more interesting than the higher ed one that I did. But I think that litigation trends webinar really reflects what's here on this slide, which is what are the most common legal attacks on diversity, equity, and inclusion. The first one is, I think, fairly obvious to folks, which is that certain DEI practices in programming take lawful aspirational demographic goals or metrics and turn them into quotas. So things like, we aspire to increase the diversity of our workforce in X way, then gets translated into 30% of our workforce has to be from X demographic group by Y timeframe, and quotas are not now, and we're not previously under any administration since Title VII, something that you should be doing, right? I mean, it suggests, and in some cases is the case, that people were making hiring decisions on the basis of a protected class. That is a very ripe ground for a legal challenge. The second is that certain DEI practices and programming violate Title VII's prohibition on disparate treatment when the applicant selection, benefits, compensation, or other terms and conditions of employment are based on a protected class, frankly. So Brian will talk a little bit more about that in the upcoming slides about, what the risk spectrum looks like when it comes to doing programs like that on the basis of a protected class. Third, claims that DEI practices violate Title VII's prohibition on segregating or classifying employees or applicants in a way that would deprive them or tend to deprive them of opportunities or otherwise adversely or negatively impact their status on the basis of a protected class. And then fourth, and probably my favorite one to think and talk about, because I just think it's such a broad bucket, and we'll talk about it in a bit when it comes to thinking about diverse supplier programs, but claims that certain DEI practices and programming violate Section 1981 of the Civil Rights Act, which prohibits the use of race in making and enforcing contracts. And I think I've certainly seen an uptick in 1981 claims over the years in a way that I hadn't seen before. I think mostly related to damages, the amount of damages you can get, and the fact that you don't have to exhaust your administrative remedies before you can file a 1981 claim. So something important to remember, and this is why I think it's so important to be careful and thoughtful with your approach, and why deleting all your DEI programs and the word diversity from your organization isn't the right answer, and neither is, in my humble opinion, and neither is this kind of we're going to really dig in on this and kind of try to stick it to people, and we're going to show people that we're not going to change any of our programs. I think my dad would say with any issue, the right answer usually lies in the middle, and I think that he would be right in this particular case. And this is one reason why I think that he's right in this particular case, which is the law regarding diversity, equity, and inclusion contains risk on both sides. I think we are going to see an uptick in reverse discrimination claims by white and or male candidates. I think that also others who maybe haven't had the same type of attention or felt they had the same type of protection when it comes to a protected class we'll see an uptick in claims related to those groups of people. We saw this with the SFFA decision in the higher education context, where it was Asian students who were alleging that they were treated unfairly in the admissions and application process. I think we'll see more of that too. And I think we'll also see claims where folks are saying, look, this hiring process, whoever was in the hiring pool, whoever was in your finalist pool, was selected because of their race or their gender, and it's a zero-sum or win-lose game. Meaning, and Brian and I love to talk about diverse candidate slate policies. We'll talk about those in a minute. But that's a good example of this kind of zero-sum game, which is if you have a policy that says you have to have 3 finalists for a position and one of them must be X, then that could mean that somebody who was more qualified for the job wasn't chosen because they aren't X. And I think that we'll see an uptick in that as well. But similarly, I think we will continue to see direct discrimination claims by diverse candidates and people who are diverse already in the workforce, alleging that although in the hiring lineup they were a part of the pool, so they were one of those 3 candidates, they weren't really considered for the job. And that, over and over again, I was put in this finalist pool and I wasn't chosen, and it really has caused me significant harm. And so I think it can feel like a no-win situation right now for people. And I think that the key to that is to really think about this kind of risk continuum that Brian is going to talk about now, and where your organization falls on that risk continuum and what kind of programs, will best serve your organization and the people in it.
Yeah, it's sort of funny. You think about the last slide, there's a big case. You can Google this. It's in the news and it's had a lot of press involving the former Miami Dolphins head coach, Brian Flores. And the whole issue of Rooney rules, that diverse slate requirements, that came out of the NFL initially, or at least was certainly highly publicized, where requirement is to have at least one or two sort of minority coaches in the final slate for consideration as part of hiring. You might ask yourself, how did Brian Flores figure out that he wasn't truly considered? Because two things. Number one, people on the selection committee, apparently within the organization that was doing the review, told another coach that he'd already made a decision. Of course, they'd already made a decision that was not Mr. Flores. This is before the interview actually happened. And then his friend texted him and said, hey, congratulations. I heard you're going to be the new coach for XYZ. Of course, he texted the wrong Brian, who I'm really sympathetic to as a Brian. But anyway, so that turned out to be, Exhibit A in the complaint. Not everything's that clear, right? And the same it goes with these constructs we're going to walk you through. When you actually look at all the individual cases, sort of like the Miami Dolphins case, they're all extremely fact-specific, right? But when you synthesize them down, there are sort of thematic points that carry through across the cases. And we're going to have a slide here in a little bit that talks about things that we consider to be the highest level risk. And we'll walk you through these. But when you're looking at your overall programming, I think it's helpful to understand thematically, in sort of a non-lawyer way, in some ways, sort of where the lines are. And I think the first general construct that I would encourage you to think about is when you're thinking about your programming, the individual tactics, I would say, that you're using to engage in good sort of EEO activity. Certainly the more inclusive they are, the safer they are legally. And certainly the more exclusive they are, the more problematic it becomes. And again, why is that? If you think about Title VII, things that are exclusive start to bump up against something that people don't think about much anymore, the anti-segregation provisions of Title VII. But certainly to the extent that things are exclusive, what that really means in a legal sense is that participation in programming or non-participation or selection or non-selection is based on, quote, race, sex, national origin, age, etc. And it's when you base it on a protected classification, and that is sort of the criteria for participation or entry, that's where you sort of run up against that issue, because you're now making a decision, a selection, a design decision that's based on race, it's based on gender. But it's funny, we've been having a lot of conversations with people about this. A lot of people will rightly say, yeah, I think we're good. There's not a single thing we have here within XYZ Corporation that isn't open to everybody. We include everybody and everything. And there's nothing about our DEI programming that in any way discriminates against individuals. And I'll say, really? Okay, so let's talk about the XYZ conference that I saw on your website that you just had last week for Y demographic. Sounds like a really great program. Tell me about how the participation was selected. And if you go into some of the discussions about who got to attend and who not got to attend, sometimes you'll figure out that some of it was, in fact, based off of race, gender, national origin, etc. Is that a problem? Well, on a risk spectrum of issues, it may not be at the highest level of problems because it's not related necessarily directly to hiring or promotion or other things. But technically, is it a program that is exclusive in some respects based on race, gender, etc.? In that particular example, it was, right? The same thing I would say about ERG groups, right? Something that Sarah and I get questions about all the time. Is it true that because you have an employee resource group and part of the demographics that it's geared toward relates to race, gender, or other protected categories, is that prohibited? No, it is absolutely not. Certainly having an ERG group that helps people feel welcome, that allows for internal networking and support, and that helps with sort of pipeline identification and things that are important to your organization, I think that's all fine. But the devil's in the details. It depends on what the ERGs are engaged in. And to the extent, again, that they have pieces of their programming or activities that are exclusive, the fact that that part of it is inclusive doesn't necessarily get you off the hook. And so I think when you're looking at programs, you can't just look at the titles of the programs. It really requires you, as part of an assessment, to sort of go into an evaluation of the individual criteria. And then likewise, it's also helpful every once in a while to take a high-level look at who actually participates, who actually does show up, who actually is included in things. It's a practical, operational matter. Sometimes, even though the intent is to keep it open, how it's communicated or how it's operationalized doesn't make it so. And that's where sometimes you start to run into different issues. And so, for example, within the new administration, you'll see the Office of Personnel Management issued a memo that said to internal agencies, having ERG groups, for example, are perfectly fine, provided that the programming and participation they engage in are not exclusive. So that's one example of how this kind of plays out.
Yeah, Brian, maybe another example is what you and I were talking about earlier today with the King and Spalding case that just came out yesterday in Maryland. Yeah. Our great colleague, our department chair, Elena Marcus in Maryland, sent us this case. And it's really interesting because a law student sued King and Spalding related to their Leadership Council Legal Diversity Summer Program. So LCLD is the name of these programs. And that particular program, and a lot of law firms were in the news for this. I was a little surprised that this language still existed at this point. But the language in the program was that candidates for the program must have an ethnically or culturally diverse background or be a member of the LGBT community. And the law student who sued King and Spalding said, I didn't even apply because I'm not any of those things. The court dismissed the case on a motion to dismiss and said she didn't have standing to sue because she didn't even apply for the role. So I think that's an interesting legal argument, which is if you ever get in this position and it's somebody who didn't actually apply to your job because they saw the posting and felt that they couldn't, I do think it's an interesting legal argument, but ultimately that kind of language that would fall into this bucket of what Brian's talking about is exclusive, that you have to be something to have the job. I certainly think, again, now and before, even prior to January of this year, that is not something that you should be doing. It would be very risky to post language like that.
Yeah, absolutely. And the King and Spalding case is also a good example. Sarah and I were talking about this before we went online. It's a good example, too, of you've got to be very careful about what you read as far as the headline. I think the headline on some of this would imply that the nature of the program that they engaged in was lawful and that therefore they, quote, won the suit based on that. And that's not really the case. The decision was based on a technical issue related to jurisdiction, an important distinction, but does it necessarily give the legal green light from at least that court's perspective to the underlying actions? It does not. And so I think, again, even on cases, you have to be very careful about digging into what are the facts, what's being alleged, why was the decision reached in the way it was. That's a great example, Sarah. So separate from efforts that are out there, sort of different types of activity, there are also what I would call action points along the way that also sort of flow down the risk. And so as a general sort of thematic issue, again, we're trying to think broad brushes here. Things that you do internally to make sure that you have a welcoming environment, policy issues that you do in your handbook to make sure that they're thoughtful of people regardless of background, and break down barriers and provide opportunities for people to advance across the spectrum, typically are not going to get you into a lot of legal trouble. Likewise, things that sort of happen on what I would consider to be the sourcing side, or going back to Sarah's good point about contracts, into the pipeline side of things. You're trying to make sure that you're casting a broad net or getting broad number of applicants, or in the case of supplier diversity initiatives, contractors to sort of come and sort of be participants with you, to apply for you, to stay with you. Things that you do that sort of, even if it's targeted to try and, as part of the net, even if it's targeted particularly to individuals of diverse backgrounds, to make sure that you are getting a broad pipeline. Typically that's safer because ultimately you're not getting to do something that's really the ultimate hiring decision. The closer you get to selection, criteria for how you pick people, criteria for how people are screened or individual contracts are screened, things that walk closer into the ultimate selection, even if it's not the final selection, but just close to it, like things like interview slates. that's where you start to get into difficulties, because now you're making, quote, a decision based off of hiring and firing and promotion, et cetera, based on race, sex, national origin, et cetera, when you're making sort of actual outcome decisions along the way. And race and gender is, quote, part of that metric that you're sort of using to do the evaluation. That's where it gets to be sort of more problematic. So things that sort of cast the net are fine. When you draw that net tighter, that's where courts tend to take a harder look. And so how do you see this flow down into actual programming? Well, again, things like policies and barrier modification and sort of general outreach, even if it's somewhat targeted, typically does not tend to be that restrictive. And you don't see a lot of legal firepower to that. But when you start to get into things that really start to impact actual hiring or promotion, things like targeted leadership development and mentoring activities that aren't open to others, or where there's not similar programs to others, that starts to actually have actual outcome decision impacts on people's employment. It's also technically a program under Title VII that is, quote, segregated in some way, depending on how it's constructed. And so you start to see more cases along that line. And then certainly, separate from diverse slate requirements, like Sarah said, things where you actually have selections that are based on implicitly or explicitly certain identified goals or demographic metrics. That's just straight up disparate treatment discrimination in some circumstances under Title VII. And that's absolutely the most risky thing you see.
Yeah, and Brian, I think that includes diverse supplier programs, especially diverse supplier programs that have a numeric component. So, perhaps a diverse supplier policy or program that says something like, we strive to enhance the diversity of our third-party vendors and contractors, and we take steps to identify diverse suppliers. I think that is probably okay. But most of the diverse supplier programs that I've seen have a numeric target. They say, 30% of our contractors will be from X or Y group, and it's part of the procurement process. I think that is a very big risk right now. And in fact, I have clients already who are seeing a blowback in demand letters related to diverse supplier programs. And it's from typically like majority owned businesses saying we weren't chosen to be your vendor for X because of this same kind of thing with a diverse slate requirement. It's a zero sum game, and we weren't chosen because you had to follow your policy and choose X. And we think that's a violation of Section 1981, which prohibits race discrimination in contracting. And I think that is a good legal argument. I think diverse supplier programs are very risky if there's a numeric figure attached to the program.
That's a great point, and I'll just call out a couple of other things related to that. It's not just goal setting and whether goals turn into quotas, which we're going to get into in a second, but it's also scoring, right? So when you think about, some people say, well, we have goals, but they're aspirational. We don't use them as quotas. And yet, when you look at the underlying scoring for how you pick contract A versus contract B, diverse contracts in some cases might get a plus factor in a score. Well, that can be problematic in some circumstances. And there was a case about a year and a half ago at Ultramar that had to deal with the Small Business Administration on the federal level that talked about their sort of minority and diversity sort of programming with respect to some of the Small Business Administration loans and how they were scored. And in that particular case, individuals were given a plus factor to the extent to which they were deemed to be part of an underrepresented group. But it didn't make any difference whether you were Bob Johnson, the owner of the Charlotte Hornets, and a multi-millionaire versus somebody else. You were considered to be, quote, disadvantaged under that program. The court said, well, no, I mean, that has all sorts of equal protection and other issues. And the Small Business Administration actually was enjoined from that program, and they had to go back last year and actually rewrite the guidelines for participation. And so that's a great example, Sarah, of sort of how this can sort of pop up in weird ways. I think just understand that the more you get down towards actual selection metrics in any form, whether that's scoring or outcomes that you mentioned, that's a problem. And that's why this is also a problem. This is this is proxy season, 10K season, so we bring this to your attention. This is one practice that sometimes can be a little in vogue. And this is when you tie executive performance evaluations for compensation to certain DE&I activity. The reason it's touchy is certainly it's one thing to say as a matter of performance evaluation and bonus linkage that you want to make sure that people are complying with the law, right? And that law includes, among other things, not discriminating, not harassing, not retaliating, engaging in good equal employment opportunity practices, and supporting your HR team in doing that. All of that, I think, is perfectly fine. And but when you also then in turn say, we have a leadership goal across the organization tied to national U.S. and international EU goals to promote and advance women in X category, and we want to make sure that we have at least Y percentage of women in Z category by 2026. And by the way, that's just an aspirational goal, but if you don't hit your goal, your metrics for your bonus calculation are going to be graded downward. Some courts would look at that and say, well, you're saying it's a goal and you're saying it's aspirational, but the message you're sending is if you don't hit it, there will be consequences. And some courts would say, depending on how that's operationalized and what the evidence of the case is underlying that, that turns a lawful goal into an unlawful quota. And so a lot of times right now, we're seeing people sort of reassess sort of how they sort of score that out and the extent to which they really do want to link that to compensation. Whenever you have that kind of pull, it does provide sort of an extra sort of chit for plaintiffs and to argue that, in fact, what's going on sort of is straight across the line. Again, it's all very fact specific. We're not saying that every circumstance in this case where individuals engage in this kind of activity is problematic, but I think in the current environment, absolutely, I think people are looking at that. And so if you're looking at your own practices for 2025, it's a good idea to sort of reassess how that's linked. So let me give you a couple of examples about how things are operationalized. We'll talk about the hot button issues that we're seeing across the country that we think are the riskiest. And then we'll talk about some practical advice before we end the questions. So just one thought, when you're doing your own assessments, we think it's a great thing to do assessments. We're helping people across the country do a lot of privilege risk assessments right now. I would encourage you, if you're going to do it, to make sure it's privileged, whether that's internally done or externally done from folks like us. But when you're doing assessments, don't just look at what the name of the program says and how it's described, but think about how it actually happens on the ground. And what I mean by that is you're going to need to do interviews. You're going to need to talk to people about how they interpret the messaging, even though they've gone through training and assessments and they have guidelines and parameters for how they're doing things. What are they telling people? What are they hearing? Here's an example, sort of after review of her department scorecard, which had some challenges. I mean, it wasn't as diverse as they wanted to be. The manager says, I don't want to see myself on that scorecard anymore. And so she goes to their hiring managers and the staffing team, and he says, okay, look, the next 10 unit hires need to be X, which, by the way, we think it's okay because all I'm trying to do is match our goal. Can't do that, right? That goals are supposed to be aspirational. I mean, when even though HR might be setting an aspirational goal, when they turn around and then sort of operationalize it to the hiring team to say, by the way, X number of hires need to be Y based on X demographic, that's where you start to run into stuff. Likewise, that includes things where you don't say it directly, but you say it indirectly. So sometimes people won't say X number of hires need to be Y, but they'll say, I don't care how it happens. Don't put me on this scorecard again. I don't want to see myself in the red, right? Is that an express directive to sort of engage in discriminatory hiring? No. Is it sort of an indirect implication to do so? Probably, right? So that's the kind of thing I think you need to look at. And you'll see other examples too, where people will say, you need to change cutoff scores or other kind of issues based on demographics. Again, sort of prohibited by Title VII. Here's another one. Here's the last one I'll just mention too. Sometimes we'll say, well, it's not part of the scoring. But if all things being equal, everyone's sort of the same, we'll use it as a tiebreaker. Well, two things I'd say about that. Sarah might have some opinions, but number one, all things aren't equal. no candidate is ever exactly equal. And sometimes people use that as a little bit of a shield to sort of justify sort of the action they want to drive based on certain outcomes. But even if it was true, you still can't use race, sex, gender, national origin, et cetera, as a tiebreaker, because you're still using it as a factor. It doesn't really, it helps a little bit, I guess, in concept that it's a tiebreaker and it's not used in all circumstances. But ultimately, it's still a decision based on those factors. But yes, Sarah, do you have any thoughts about that? Or
no, not that in particular, but Brian, it reminded me a little bit of the conversations we've been having this week about the American Bar Association. So this kind of like how your messaging comes across to your stakeholders really matters, and being thoughtful with your internal and external communications is so important. The issue with the ABA, they recently suspended their DEI standards that they use when they accredit law schools related to diversity in employment. And this was the standard. It says, consistent with sound educational policy and the standards, a law school shall demonstrate by concrete action a commitment to diversity and inclusion by having a faculty and staff that are diverse with respect to gender, race, and ethnicity. And they got, a nasty gram from attorney generals of certain states that said, look, even having that language by saying essentially a term of accreditation is that you've demonstrated by concrete action. I think that's the problematic language in the standard. You've demonstrated by concrete action a commitment by having a faculty that are X, Y, and Z. The ABA temporarily suspended that standard, to, I think, probably try to reflect whether it encourages or suggests that they are making hiring decisions based on race. So that kind of language like that out there, that you might read that and think that that's not a directive, and that there are, that is a good way to describe it. I would take a look at all of that language, both internal and external, and see if there's a different way to say it where you can still meet your goals of having a diverse workforce, but not making these suggestions that could later be subject to some second guessing. I have I won't say, because I think somebody from this organization may be on this webinar, or they were at least signed up to attend, but I saw a communication the other day that I thought was really smart. And it used the language diversity of thought and perspectives. And I just thought that was really well done, because it people from different backgrounds have different thoughts and perspectives, socioeconomic areas of the country. It's a very broad definition of diversity. Some people might say, and I completely understand it, that it waters down diversity. But I do think it was a thoughtful, and I think has still the potential to be impactful way that the organization was describing what they were doing. So I think those internal and external communications, looking at not just what was the intent behind them, but how could they be perceived, is an important exercise to do right now.
Yeah, absolutely. So let's just go through a couple other slides about hot button items, and we'll close with some practical tips. We want to keep you on time, but I mentioned that sort of how goals are operationalized matters. Certainly the same is true for programs. You need to look at individual programs. I'm not going to go into this slide in detail. You can look at it later. But again, programs that can seem fairly innocuous, depending on how they're run, can run afoul. And this goes with respect to ERGs, but this happens with all sorts of other good, well-intended programming too. What typically happens in this space is originally as designed and constructed, things will be fine. It'll get passed by lawyers like me or folks internally for blessing, and it'll go up. But over time, over the years, things will happen that people want to sort of tweak or expand on that they think are helpful. And sometimes they are helpful. Sometimes it changes the ultimate design that was originally okayed. So again, this is a good time not just to look at sort of things like goals, but your programs that you have, what are they actually doing on the ground? Who's doing them? I think that's really important. As for the most common attacks that we see, here are the top list. We came up with certainly 8 here. We've mentioned several of them, certainly aspirational diversity goals. Goals themselves are fine. And goals have been a part of affirmative action on the federal side, for example, for years. But if they're goals, especially with very short times for achievement, with huge increases with limited time, you might get second guessed about how that's going to be. And it's interesting, at the end of the last Trump administration, the OFCCP actually sent demand letters out to a variety of different sort of corporate Fortune 500 companies asking this very question on their own. No complaints. They actually found the things off the website and targeted and said, hey, you say you're going to increase leadership for X demographic and Y band in 2 years. That's a massive increase. Tell us how you're going to do that without violating Title VII. So you might get second guess, and they're going to be looking for that. Certainly talked about manager performance ratings and diverse slate requirements. Somebody raised a question about this in the chat. Certainly internships, mentorship programs, grants, scholarships, again, that are exclusive to certain groups or that the administration might view as, quote, a proxy for those same things, where you sort of back into an outcome internally based on facially neutral factors. You might get sort of second guess depending on the construct of that. Likewise, employee retention programs, employee development and training programs, supplier diversity. We've already talked about a good bit of that. But anything else you want to say about this particular slide, Sarah, before we jump into the tips?
No, I know a lot of colleges and universities are interested in scholarships, and I assume corporations also would be interested in those. I think that's probably a separate webinar in and of itself. But in general, you need to be very careful about those scholarships and awards that are targeted or limited to racial or ethnic groups or genders or sexes or any protected class.
Okay. Let's use our final time here just to go over a couple of tips I think is helpful. And again, we're trying to pull way up and give some sort of general guidance, not necessarily advice, but some guidance about how to think about this. I think the first thing you need to think about if you're going to do some sort of self-evaluation is you need to think about the particular factors we noted here and look at the individual components along the way and ask yourself this question: are we okay with it? But the we matters. You might be okay with it, but is your executive team okay with it? Is your board okay with it? Do you think your shareholders are going to be okay with it? You got to make sure that you're picking the right groups to get their input. To the extent that you keep what you're doing or change what you're doing, you're going to get blowback potentially on all of that. And I think it's good to sort of socialize all these issues up and down the chain. These aren't just legal issues. These are business issues, and I think they need to be thought about accordingly. Likewise, when you're thinking about risk, we're lawyers. We talk about lawyer risk, right? That's what we do. It's what we focus on. But there's lots of risk in the world, right? There's PR risk, there's customer risk, there's market share risk, there's all sorts of other risks that you need to balance. Don't just think with the legal lens. You need to get other people sort of involved in all this. And likewise, like we mentioned before, we know it's sort of 10K season. But it's also the season that people are putting out your ESG reports and other things. Think long and hard about your internal and external communications that are going out in this current environment. And when you do that, take a hard look at things like your human capital section and your S part of your ESG reports. Do you need to clarify certain things? Do you need to sort of modify the language so that it avoids implying that you're doing things that we listed here that you may not be doing? And likewise, to the extent that you are doing good work in this space and are doing things that are absolutely okay, do you need to caveat in some way? Do you need to add disclaimers that say not just the positive of what you're doing, but the negative, that you are not doing certain things, we're not doing incoherence, we're not giving preferences. And so for a lot of people, we're going back and sort of both sort of editing language and then adding language in some respects. And in many cases, for some people, we're deciding to clip entire sections. You have to ask yourself, depending on the report you're doing in, is this required? Do we need to publicly say it? What's the downside if we take it out? What's the upside if we include it? I think those are all sort of important things. But Sarah, you want to talk about the next slide here?
Yeah, sure. So some practical tips. You be clear in your trainings that any diversity goals, targets are not a quota or a maximum ceiling or a set aside. And you want to be really careful to give examples of what you mean by that. So how that actually looks when it comes to to make hiring decisions and to put people in roles. I've seen it trickle down ineffectively where the organization is saying, we need to enhance diversity, equity, and inclusion. No one at any point along the way has said anything about, that you are supposed to hire someone on the basis of the race. But by the time it gets to the hiring committee, you have people sitting in the hiring committee saying, well, the organization says that we're supposed to do that we're supposed to increase diversity. So I think that means that we need to pick Sarah for the job because she's a woman. Like I've just seen it get lost in translation by well-meaning people so many times. And I think being really clear with your HR folks and in your communications is a really important thing to do. I think this might be on the next slide, but Brian and I were talking earlier about how, we've said along the way at various points that we've recommended including in communications, like this, we do not permit hiring on the basis of a protected class in messaging around diversity, equity, inclusion, and how generally comms people don't want to do that, but how in this moment it might be advisable to do something like that and to listen to your friendly neighborhood lawyer, even though, again, we understand why that's not the optimal thing to do. I think the reality right now is that would help you if you were in a situation where someone was questioning your communications. And like I said before, just really thinking about how might this sound, how might this come across. Kind of end where we started, which is I don't think people should overreact. My phone is ringing all day long. Like, do we need to get rid of all of our DEI programs? No. Please do not do that. I think it's the wrong thing to do. I don't think you have to do that. I think you just need to be really thoughtful about, does your intent match what you're putting out there? And if you're putting something out there that is encouraging illegal behavior, how can we think about that differently? As Brian said, we're doing a lot of privileged assessments right now for our clients related to this area. Happy to talk to folks about it if that's something that you're interested in. Really important, I think, to pay attention to agency enforcement memos. They are not binding, they are not law, but I think they certainly signal to people. If anybody thinks it's ambiguous at this point, I'm not sure what to say, but it will signal to people how the administration views this topic. And I think it gives kind of helpful insight. A very recent example of that is a February 14th Dear Colleague letter that was issued by the Department of Education. The Dear Colleague letter purports to interpret the SFFA Supreme Court decision about the limited use of race in collegiate admissions. And the Dear Colleague letter, agency guidance for those of you that don't deal with the Department of Education frequently, this agency guidance essentially says that the holding in that case, in the admissions case, means that if an educational institution treats someone of one race differently than it treats another person, then you violate the law. And it gives a lot of examples of ways that institutions do that, including things that I just think are a tremendous stretch, like graduation ceremonies. Sometimes schools will have the overarching graduation ceremony, then they have them by school, and then they'll have like the Black student graduation ceremony. And this Dear Colleague letter is saying that things like that are a violation of the law. I don't know about that. Yesterday, a lawsuit was filed again in the District of Maryland seeking to enjoin that Dear Colleague letter. So we'll see how that plays out. But the position of the Department of Ed is that any separation based on race is illegal discrimination. Again, I don't know about that. To be determined, I suppose. Take this official guidance as instructive, but with a large grain of salt. I think some of this is meant to cause a reaction, and looking at things, reading them carefully, talking to your legal department, talking to us anytime, talking to whoever your counsel is anytime, and being really systematic and thoughtful about this from my lens is the right way to go. We did not get to questions, Brian, so we can follow up on those with anybody who submitted a question after the webinar.
Absolutely. I would just say, just to close, I think those are all great points, Sarah. Again, like Sarah said, be careful what you read. there's lots of information that's going to be coming out, but we'll see. I mean, I think in the opposite may also be true. I mean, I've had a lot of clients who come to me and said, I'm waiting for the Department of Labor to issue some guidance on how they're going to view this. When is the EEOC going to publish something on how they view this directive? My guess is they're probably not for a while. When they do, it's going to be very high level. Why is that? Because from the administration standpoint, they would rather you overreact and eliminate all of it. And I don't think you need to do that, right? And frankly, I'm not even sure the administration thinks you need to do that. But I think, is there going to be a ton of very detailed sort of tactical guidelines coming out of the administration on these issues? Probably not for a little bit. And so you're going to have to feel your way, at least for now. Speaking of feeling your way, I'll just close with one example. I think it is important, again, since we're all in this bubble together. I do labor employment. Sarah does labor employment. A lot of people on this phone call probably do risk management or versions of labor employment or certain things with admissions. You're in this space a lot, and you're used to the terminology. You're used to the programming. But keep in mind, day-to-day people that you run into aren't. And they're really sensitive right now, and they're hypercharged. And because of that, sometimes explaining what you're doing and why you're doing it in this environment, I think, becomes more important. So I'll give you one example as a close. A client who called me the other day, and they were doing a simple update email that they do every year at the beginning of the year, asking people to update their HRIS profile. Pretty innocuous, right? What's your address? What's your information? Has anything changed? What's your emergency contact? Embedded in the HRS profile is your race and gender demographics, which can also be updated. They got 4 whistleblower complaints about it, right? Pretty boring, right? A pretty boring thing. Nothing wrong with it by any means. But in the environment, could they have said in the email, by the way, we're asking for this update as we always do. It's confidential. It's information to keep our record keeping accurate. And by the way, we also have to do EEO and other reporting. And therefore, it has race and gender information in that. Please assure it's accurate. To the extent you have questions, let me know. Yeah, they could have explained it, and it might have sort of reduced the issue. And so I think that's the only thing that I would say is, in this environment, there's lots of things that you do day in, day out that are perfectly fine, but you might still get second guessed on. And so just step back, think long and hard about sort of what you're communicating, who you're communicating with. Think long and hard about whether it might get misconstrued. And when in doubt, you could add language that sort of talks about why you're doing it and how you're doing it. And hopefully, over time, that a little bit of this will settle down. But certainly, if you have questions about this, Sarah and I are always available. We have a whole team of people here dedicated towards the transition with the new administration in all areas, both in legal issues like labor and employment and education and other things, contracting, but in all industry sectors. So certainly feel free to go to that. You'll also see legal alerts, other webinars, other things that we've done. They're all available there, and we're certainly happy to help you anytime. Thanks again, everybody.
Thanks so much.